Good morning, everyone. Welcome to our webinar about how to remove a director, dealing with rogue directors and business divorces. My name is Jodie Thomson. I'm a practice leader in the disputes team at LegalVision, and among other commercial and contract disputes, we deal with a lot of director and shareholder disputes where businesses need our assistance. Before we start, just a couple of housekeeping matters. We will email you a copy of this webinar recording if there's anything that you wanted to check back in more detail. If you've got any questions along the way, just submit them in the chat box on the side and I will try and answer as many as I can at the end. I'll have 15 minutes or so at the end to deal with some questions. And we'd be really grateful if you complete the survey after the webinar, giving us some feedback. So today, as I said, we're dealing with directors' disputes, but we're also very much talking about shareholders. For smaller and medium-sized businesses, most of the matters we deal with directors who are also shareholders. So in some parts, I'll use those terms a little bit interchangeably in terms of generally dealing with a dispute, but we'll also talk about the difference between them and company structures and where that's important. We'll go through some common types of disputes that we see, some steps you can take to prevent a dispute altogether. If you do come across a dispute, how to deal with it as a first step. Will help you, guide you towards resolving a dispute outside of court, but also what it looks like to go to court and what your legal options are. We'll finish with some questions, as I said, and then give some information at the end about our LV membership. So, as I said, I'm going to explain a little bit about the difference between directors and shareholders and company structures. Now, this might be very familiar territory to many of you, but in many cases, we find clients often don't have a real understanding about what the rights and obligations are of a director and a shareholder when they are entitled to take action about the way a business or a company is being run. And again, what those responsibilities are, it's very much at the heart of most of the disputes that come to us and that we need to resolve. So to be very, very brief and simplified, a director is a person responsible for the day-to-day management of a company's business activities. A company can have a sole director, who would also be the secretary, or you can have many directors, but all of them are equally responsible and have quite strict duties and obligations under the Corporations Act, which I'll go into a bit later. A shareholder is somebody who owns shares in a company. The shareholder can vote on the strategic direction of a company, including who the directors are and when to remove them, but they otherwise don't usually get involved. They don't have to get involved in the day-to-day operations. In many cases we see in smaller to medium-sized companies, the shareholders are also directors, or some of the shareholders might be directors, and in many cases they might also be an employee on an employment contract and therefore falling under the protections of the Fair Work and other employment standards in Australia. Very often when we see company disputes dealing with director disputes, there are shareholder issues and employment issues wound up together as well. And while they're internal business disputes, they can really stop the operation of a business or a company functioning. And if they do end up in court, they can end up with indeed the winding up of that company. So they really need to be addressed promptly and certainly avoided from the start if possible. Now, some of the common types of matters that we see, as I said, we see quite a lot of these. Look, they have one thing in common. At the heart of them is a relationship breakdown between the people running the business. It might be recent, it might be long-standing, but it's usually enough to, well, certainly to prompt clients to come and get some legal advice. The type of matters people are having disputes about include perhaps the other director misappropriating funds, spending money irresponsibly on the company's behalf. Sorry, when I say misappropriating funds, perhaps for their personal use, because directors, of course, would have access to the company business accounts. They might be removing access to the business records from the other directors, or not giving the other directors access to the management of the business, so perhaps excluding from meetings. Maybe they're not keeping proper books and records and accounts, and exposing the other directors to problems there as well. In terms of legal issues, the legal options around these type of disputes can be pretty complex. So I'm keeping it simple from the start, but if you are, they really fall into two types. One is where the director is breaching their fiduciary duties, which means their obligations to the company. There can be an action that a director can take against another director. This is usually done by something called a derivative action, because it means that you have to ask the court for permission to step into the shoes of the company. All legal actions around director and shareholder disputes are very much focused on what's in the best interests of the company. So they're looking at what's in the best interest, whether or not the company has been harmed, and what legal remedies there might be to protect the company. It's not so much about individual directors or shareholders needing to be reimbursed. It's very much about the focus on the company. The other legal category where probably more of the matters would fall into is shareholder oppression. This is the case where a minority shareholder feels that the actions of the other directors, it can also be taken by directors as well, but where the actions of the other directors and shareholders are oppressive and not in the best interests of the company. So they're roughly two of the types of legal options that I'll get into in a bit more detail later on. So the best thing to do really is to try and avoid these types of disputes occurring. They're very disruptive to business. They are obviously emotionally very stressful and exhausting for the parties involved. And if you do need the help from a lawyer, they can be quite expensive to deal with, because it's not always easy for lawyers to work out what's going on and help parties try and work out a resolution. So there's not a quick fix as such, so you can be looking at quite serious legal fees to try and resolve it. So the first thing I talk about is knowing your director's duties. This is really important, and we see many parties come to us for advice, and it's clear that they don't have a really sound understanding of what your duties are as a director. And so, it applies to both cases. It's one thing to know if another director is breaching their duties and not doing what they should be doing in line with the Corporations Act to run the company. But it's also really important that you know what your own duties are, because they're often intertwined. Very often we have clients who might come in with complaints about the way another director's behaving, and when we look more closely, we can find that perhaps our clients have left themselves exposed as well. So these might be well known to many of you, but we really reinforce them because some of these come up a lot in our directors' disputes. So again, focus is on what's in the best interests of the company, duty to act in good faith, duty to exercise powers in the interest of company stakeholders, duty to act with care and diligence. It's very important that directors maintain proper records and prepare financial reports. If you're one of 4 directors, it's not enough that you have outsourced that to somebody else and you're not aware of them, or perhaps the other director's looking at it. All directors need to be familiar and aware of the financial records of the company, not misusing company information, not disclosing, a duty to disclose any other personal interests, and of course not trading while insolvent. Again, this is a joint responsibility for all directors. So if you have concerns about another director and the way they're behaving, it's also really important to shine that spotlight on your own conduct, because as I said, we see these things come up in disputes, and it can end up very quickly with a lot of finger pointing from both sides. And being very aware of directors' duties from the start makes it certainly a better place to avoid disputes. We'd also recommend investing in corporate governance. Depending on the size of your company, it really depends on what extent that's necessary, but it's necessary to some extent. If you're a slightly big company, it might include training staff in all of the obligations that are required outside running the business that you run, of course, which is very important. But to make sure that you're complying with all of those ASIC obligations and all of the formal steps that are required, the meetings, the process of meetings, keeping records, and so forth. Have a good bookkeeper from the start, or an accountant who knows your business well. This really relates back to that duty to maintain proper records and prepare financial reports, and to avoid trading while insolvent. All of those things require all directors to have a very close understanding of the financial position of a company. Even if you're a bigger company and you actually have employees who might look after that. Having a good bookkeeper or a good accountant will ensure that your company's records are up to date, they're accurate, and it makes it a much easier job for all of the directors to have access to those and to know that they can be relied on, and to get ahead of any issues that there might be in the running of the business with other directors or with the solvency of the business or otherwise. And lastly, this seems obvious, but we see, I would say, more than half of the disputes, that the directors and shareholder disputes that come to our office, the companies don't have some basic company documents in place. We recommend a shareholder agreement and a company constitution. It's certainly possible to operate a company and a business without these, but if things go wrong, it makes it a lot more difficult to resolve disputes and to deal with issues like a dispute where you might have a director or a shareholder leaving. A shareholder agreement in particular will include a template for dealing with a dispute, might have a dispute resolution clause. That's something I can talk about in a little bit more detail later on. But it also maps out those rights and obligations of shareholders, and it might have a restraint of trade if a shareholder sells their shares, just to make clear what their obligation is in terms of perhaps going and working for a similar company or otherwise afterwards. The company constitution likewise can set out, for example, the voting rights and how the shareholders might be able to vote to remove or appoint a director, so that if you are having any issues with the directors, you've got a very clear blueprint on how to deal with things. In relation to disputes, these type of agreements are really, really important. So if you do have issues with a rogue director, and when we say rogue director, we just mean a director who's causing problems for the business in some way that you're concerned about, that you feel might be damaging to the business. The first thing we do is seek advice. Now, one issue we have a lot with director and shareholder disputes, often because the parties, as we say, are directors and shareholders and employees, is a conflict of interest. So it's important to understand, if you're seeking legal advice, whether you're seeking that legal advice on behalf of the company, or if you're a director as an individual director. Because if we're giving legal advice to a whole company, so for example, a director might come to us and say, I need some advice for the company. We're having some problems with this party who's a director. The issue there is that all of the directors are entitled to a copy of that legal advice. So the conflict is actually between the directors. So there's a conflict of interest if we're acting on behalf of the company against a director as well. So sometimes individual advice can actually be quite useful, and that might mean as a director that you go and get advice from a lawyer who's otherwise not engaged by the company or otherwise involved. That advice can also extend to accountant's advice. Like I said, if you've got a good relationship with a bookkeeper or your accountant, somebody who knows the business and the company well, you can find out what your options are and make sure you're getting some professional advice on how to deal with it. If you have a constitution and a shareholders agreement, this is a point where it's really important to look at those and check if they have dispute resolution procedures built into them. Most do, and what that means is that it is a process for parties to step through if a dispute has arisen, and that dispute can be any sort of dispute. Its dispute resolution clauses are really useful in stopping one party running off to court, really, or otherwise taking any action that might prevent the dispute being able to be resolved. The dispute resolution clause will usually require parties to take steps that might include mediation or some other steps that are well out of court to try and get to the bottom of what the dispute's about and look for a solution. Sometimes if you have a dispute with a rogue director or a director who has perhaps been behaving badly, perhaps they've been misappropriating funds or taking steps to set up their own business in competition with the company. Maybe they haven't been engaging or communicating with everybody else in the company. You might want to remove them. Sometimes that can be a possibility depending on the size and structure of your company. This is something that I'm expect will come up in the questions later on, and it's not always easy to answer because it's very much dependent on the size of your company, the structure, the number of shareholders, and whether or not you have a constitution that allows voting rights. For example, it might be that the constitution allows a majority vote of members to vote to remove a problem director, and it can sometimes be as simple as that. It's not necessarily simple though, and this is a distinction that we find we often have to make with clients. Again, this might seem very obvious if you're a larger company and well versed in this area, but it's something we come across very often where our clients might not really understand the distinction between being able to remove a director, but you can't remove a shareholder. The only way you can remove a shareholder is by buying them out. Or offering some value for their shareholding. I'll deal with that a little bit more later on as well. Among the other first steps to deal with a rogue director or any sort of company dispute with directors, shareholders, is to voice your concerns. We recommend doing this in writing. It doesn't have to be a very formal letter, but it should be formal enough that it sets out what the concerns are. Very often in these type of matters, we find parties will come to us with a shopping list of grievances, and they can be big things and very small things. And it's important to, the process of putting that in writing can be very helpful to make you and the other party realise what's a minor issue that perhaps can be dealt with informally, and what is a more serious issue, again, such as misappropriating funds is probably one of the most common that we come across that can be dealt with, and it helps parties focus and narrow the actual issues in dispute, and is also really useful if you're not able to resolve a dispute with early discussions and early letter writing. It's important to have things set out properly so that it can assist if you do need to see a lawyer down the track. So in short, there are really only two ways to resolve a director-shareholder dispute: outside court or going to court. Doing so outside of court means negotiating. It's like an out-of-court settlement. It's how most of the disputes that come across our desk get resolved, or by court order, or by one party going to court. There's different legal options available that I touched on briefly before. And I don't need to go into those in too much detail now. But the type of outcomes that can resolve a dispute, and this is the case whether you go to court or not, what type of agreement or negotiation might work? Well, in most of the cases we see, if there's been a complete relationship breakdown between the party, it's usually pretty obvious that the status quo needs to change. Usually it's the case that somebody needs to leave. In most cases, the company or the business is still able to trade and to carry on. It might be the parties agree to sell the business entirely, or in some cases even wind it up if there are perhaps some trading or solvency issues. The most common option we reach or we assist parties to reach with negotiation is that the party, either a director resigns, perhaps there's some agreement, perhaps there's a payment involved. If they're a shareholder as well, it really involves some sort of payout to the exiting shareholder. A shareholder's deed will often set out the process by which a shareholder might leave, but it's also really helpful to set that out we would usually have a deed of settlement that would actually set out the process for that. It could mean the company buying out that party's shares, the shareholder who's leaving, or it could mean some of the other shareholders, one or more, buying them out. But some sort of agreement. Ideally, that can be done with probably lawyers involved to negotiate the terms of that agreement, and then to set out those terms in a deed of settlement or release, which is then binding on the parties. One of the sticking points with this often we find is that parties don't have an accurate understanding of what the company's value is, its current market value, and therefore what the shares are worth. So we very often have parties come in and they're making demands about what shares are worth and what they require as a payout to leave, or what they think they should pay another party. Look, sometimes that can work if the parties will agree on those amounts, but more often than not, it's irrelevant because it might not relate to what the actual current value of the company is. So one thing we recommend, and we do a lot in these type of disputes, is that we arrange for an independent valuation of the company, so that the directors and the shareholders know what the company is worth if it was going to be sold, what that market rate is, and therefore what that shareholding's worth, so that when you're negotiating, a shareholder who's leaving can be getting close to market value of their shares. There's not really another way out of it. Sometimes it can be helpful for parties to attend mediation as an alternative to court. That's where you have the parties and possibly their lawyers attend an informal conference. It's not in court, can certainly be done online these days, but guided by an experienced mediator who's often a barrister or a lawyer as well, who has a lot of experience in these matters and can help parties guide them to a settlement option that's going to be suitable. Most of the matters we deal with don't go to court. And the type of terms of negotiation that can result in a settlement might look at things like splitting assets and intellectual property. So again, the buyout, restraint of trade. So if there's a director and a shareholder who agrees to leave for certain terms, they might be they will agree to restraints that might stop them going to work for a competing business, and likewise confidentiality and non-disparagement. But again, at the heart of that is having an understanding of what the company's worth, and in particular what the shares are worth. And if things can't be resolved with the assistance of lawyers and negotiating and perhaps mediating, it might be that you've got no option but to look at going to court. And that's certainly the case for some matters. A relationship breakdown can be so complete that the parties are beyond being able to reach an agreement, and they need the assistance of an independent referee, which is how the court can act. Company disputes or claims in relation to companies are made in the Supreme Court in whatever state that you're in. They have slightly different systems for doing so. For example, Victoria has a more streamlined process for these type of disputes. I think the court has learned that many of these disputes deal with smaller and medium-sized companies who don't often have financial resources for very large and complex claims, and they aim to try and keep the costs down through the process. Court actions can be, I touched on them briefly before, and this, as I said, is quite a complex area and is certainly something you need quite expert legal advice about. But it might be an oppression claim where you're claiming, and minority shareholders are claiming that the other directors and shareholders are have engaged in oppressive conduct that is not in the best interests of the company and is against the interests of those minority shareholders. It might be a derivative claim where an individual director can step into the shoes of the company and make a claim against other directors or other shareholders. Sometimes there might be a number of claims at once. Most Supreme Courts will have, as part of that court process, mediation required. And that might be the case even if you've had some sort of mediation before you go to court. Again, the Victorian Supreme Court, one of the first steps that it requires once parties have filed a legal claim is to have a court-ordered mediation. The downside of going to court is, well, first of all, it's very, very expensive. As I said, directors' disputes are expensive in any event because there's a lot of information and a lot of issues, and it can be difficult to predict for lawyers how long it's going to take. Court claims of this type are expensive, even the more streamlined Victorian Supreme Court options. They're easily more than $100,000. Now, those costs might be ultimately borne by the company, but it might often be an individual director in the first instance that has to, or shareholder, who has to come up with the funds to see through a court process. They take a long time. They can be 6 months to a year or more. The outcomes, and this is probably one of the downsides in some ways of court actions. Well, what can they do? What are the options if you go to court? Well, the court has discretion to make a range of orders, even if they're not the ones that you might seek. They might order a valuation of the company, and they might fix a price and make orders that one party buys, the company buys another shareholder out. If the court has any concerns about the way the company is being run, they might appoint a receiver. They might make modifications to the Constitution if they consider that the rules that are included in the Constitution aren't appropriate. And as a very last resort, they might wind up the company. Courts are very reluctant to wind up a solvent company, but they will certainly do so in cases where it appears that the parties, the directors operating the company, are not capable of doing so in the required way. And that's where sometimes we say to clients, they might come to us and be pointing a finger at the directors on the other side. But it becomes apparent to us that perhaps there are some issues with the way our clients as directors have been dealing with their own obligations. And what happens when things go to court is that everything is then on the table to be inspected and poked and prodded and cross-examined. So it can be quite a stressful process as well. So for all these reasons, anything that can be done to try and resolve a directors and shareholders dispute before running off to court is definitely preferable. And certainly, sorry, one other thing just before I finish up on this slide, which is the last part of the talk before we move to some questions, is if you are in breach of your director's duties, there are statutory penalties, including criminal charges and fines, which can be levied against directors who don't meet their director's duties. Far less common in small business, but still a reality. And that can also be a result of having things poked and prodded in a court claim. So another reason to certainly look to different ways to resolve them, if at all possible. Now, if you've got any other, well, before we move to our questions and answers, LegalVision has a director's duties guide, which you can download in the handout section of your webinar panel, which goes into a lot more detail about everything I've said today, in particular, all of those duties of directors, which we find often lie at the heart of many of the directors' disputes that come to us. And also coming up, which may be very useful for your business, is another webinar. It's on the 5th of May, Employment Essentials for Tech Businesses. All the things you need to know if you've got a tech business and you're employing staff. You can register at the date below. All right, look, happy to deal with some questions. We've got a few through already, and I can start looking at those now. Let me just take one to start with. How to remove a director who lies to customers and diverts customer payments to their own bank account or other business, especially if they hold other shareholders ransom. Look, this is really common type of question we get. There's clearly a relationship breakdown. There's a problem director who's behaving really badly, and there's a sense of urgency to try and stop them doing further damage to the business. How to answer this would require a bit more information about the particular company. How many directors, how many shareholders, is that director an employee as well? We really need to do a bit of detective work to look at exactly what that company structure is and to know what levers to be able to pull. For example, if they are an employee as well as a director, sometimes their obligations as an employee can be easier to tackle first. Depending on whether or not there's a constitution, you might have the numbers to vote him out as a director without having to take any other action. If you've got proof, which sounds like you do, of misconduct, you might be able to issue court proceedings or certainly start some negotiations on that basis. Another question, can a resigned director be held liable for his breach of duties in a past project? Absolutely, yes. Resigning as a director doesn't eradicate any obligations that you had during the time you were a director. So, for example, in terms of trading insolvent, if you were a director, and again, that's a shared responsibility between all directors of a company, and the company was trading insolvent, and that director left at a certain point, they could still be held liable for their actions up until that point that they left. They can't be held liable for things that happen in the company after they've left, but it certainly can extend back to the time when they were a director as well. What is the legal obligation to report to ASIC if a director is actively attempting to shift IP from the company to another party, to pursue another commercial activity that relies on that IP? They're failing to do their job as CEO to build business for the startup, but instead working for other companies. This is also sounds quite similar to many matters that come across our desk. As you can tell, we've got a director, we've got somebody who's an employee as well as a director. It doesn't say if they're a shareholder, but there's quite a lot of issues going on. There's obviously some concerning behaviour. There's not a strict legal obligation in the first instance to report to ASIC, but I would certainly recommend that in that case you get some legal advice to have a look at that company's structure and the particular ingredients of that company makeup and that dispute, so that a lawyer can advise you on what the steps might be. My first reaction when reading that is that if they're breaching their employment contract as a CEO, sometimes that can be the most effective way to pull them up on their behaviour. The challenge with reporting to ASIC is that, as you can imagine, there are thousands of companies in Australia, and ASIC is only one organisation and has limited resources. It certainly complaints and can be made to ASIC, but you might not get an instant reaction, and it certainly has limited resources in being able to investigate all of these types of matters. So that's one I would recommend getting some quite urgent legal advice. Lots of questions coming through today. This is very, very interesting. Can a director resign and just be a shareholder if the company is not trading and has no financial liabilities? Yes, a director can resign, although, again, to answer that question fully, I would like to have a look at the company structure. You can't resign if there are no other directors. A company must have an acting director. So if you're a sole director and you want to resign, you need to find another director to replace. That's actually a shareholder's role to do that, but a company can't not have a director. But if you're one of more than one director, then you can resign and remain as a shareholder. If the company is not trading and has no financial liabilities, then it's in, may not be any dividends. It depends on what the plans are for that company. But in terms of resigning as a director, then yes, you can. Are directors, another question, are directors still responsible for debts after resigning, like ATO debts? I touched on this before in saying that yes, directors can be responsible, as certainly they can. There are some ATO debts for which directors can be personally liable, and that certainly continues once they have left, if that liability occurred in the time that they were a director. The other issue we see a lot is where directors sign personal guarantees on behalf of the company. Might be for a credit application or for a loan on behalf of the company. Very often credit providers require one or all directors to sign personal guarantees, so that if for some reason the company falls over and can't pay any debts that are owed, that they've got the security of a personal guarantee from a director. And directors don't realise that personal guarantees in that regard are perpetual, which means that if you resign as a director, or even if the company is deregistered and no longer exists, you are still personally liable no matter what you do after that. And it can be nearly impossible to remove yourself from that. That's something that we see a lot, and we advise clients to certainly advise clients to get that corporate governance and a good understanding of what their directors' responsibilities are, and certainly to be very, very cautious before you sign a personal guarantee. Another question, does the ratio of the shareholders make a difference with making decisions? That is 60-40 with 2 directors owning the full amount, a private propriety limited company. Absolutely, it does. It makes a difference because it's the shareholders as the members who will vote on decisions like appointing directors and removing directors. If the company has a constitution, then how these votes, the voting powers of different shareholders can be set out in the constitution. So as shareholders, you can all have some input into what goes into that constitution and what those guidelines are. And it will often set out the percentage of shares that a shareholder has as to, often it's the case that, it might be 1 vote per share. So if you've got 60% of the shares, then you're obviously going to get more votes. It can vary depending on how many shareholders there are as well, but it certainly has an impact. One question as well here. When a director has breached their duties, that is conflict of interest, what action can be taken in court to have the director removed and penalised? So I touched on the court actions, and I haven't gone into too much detail. As I said, they can be quite complex to work out if a particular dispute meets the threshold that's needed for a matter to go to court. But a court action, you might seek to have a director removed and penalised. That can be something that a court will consider, and that might be done through as I said, a derivative claim. So if you're a director, the damage is against the company. A derivative claim means that you ask the court if you can step into the company's shoes and make a claim against the other director who has breached their duties, and there can be penalties after that. That's the end of the questions. There are certainly a lot of questions in relation to this issue, so I hope everybody's been able to get some advice, some helpful advice and some tips. Thanks for your time today, everybody. Just a few last housekeeping points before we go. LegalVision offers a membership, which is an excellent way to access legal services. By taking on a LegalVision membership, you get access to our in-house hundreds of our in-house lawyers to help sort your legal issues. It involves unlimited legal advice consultations, quick turnarounds, it's a monthly fee, and unlimited document drafting and reviews. You can book unlimited legal advice consultations as well. If you would like a consultation after today, we're offering a complimentary consultation to discuss how we can help any potential directors' disputes or other business legal needs that you might have. Leave your contact details in the survey that will appear at the end of the webinar. You can also email to reply@legalvision.com.au, mention that you watch this webinar and access the consultation that way. And that's it. So thank you again, everybody. I hope you were able to find some helpful advice from today. And we're certainly happy to help with any other questions that you've got or legal assistance you might need in this regard.